Hello everyone, this is Tom Fox and I'd like to welcome you to episode 78 of the FCPA Compliance and Ethics Report. In this episode I look at some of the key developments from the first half of 2014, including enforcement actions, opinion releases, and general ideas. I hope you enjoy the episode. Thank you very much. Hello everyone, this is Tom Fox and I'd like to welcome you to episode 78 of the FCPA Compliance and Ethics Report. Today I thought I would take a look at some of the significant developments that we had in the first half of 2014. Although not a lot happened in the FCPA world, some significant things happened. So I'd like to go over some of those with you today. I'm going to start with the enforcement actions that we had in 2014. First, in the area of corporate enforcement actions. The year started off with a bang with the Alcoa enforcement action. There was a $365 million settlement by Alcoa, and one of Alcoa's subsidiaries pled guilty for FCPA violations. All of this revolved around Alcoa's continuing bribery scheme to bribe the Bahraini National Aluminum Company to sell aluminum products, or the products to make aluminum, to this company. It was really an interesting case for a lot of different reasons. The agent who paid the bribes, Victor Dadala, an Englishman, was arrested for his involvement in the case, and he was found, his case was thrown out of court because the Serious Fraud Office in the UK could not prosecute it because the lawyers who had developed most of the evidence, who were working for Alcoa at the time, refused to go over and testify at Mr. Dadala's trial, even though they had apparently cooperated with the Serious Fraud Office on an ongoing basis leading up to the indictment. Kind of on the flip side of that, the person who received the bribes, the president of the Bahraini Aluminum Company, did plead guilty and was sentenced to jail in the United Kingdom. Really, I thought it was very interesting that Alcoa itself, the parent company, said that the settlement showed that nothing that the parent company had done or had no involvement in this matter. Nevertheless, they paid $365 million. That's a pretty big payment for somebody who had, or a company that had no involvement in the matter. So the first week of January started off with a pretty big bang. Later in late March, we had the HP settlement, which Hewlett-Packard, which was an ongoing matter. For those who follow my blog, I've talked about this for several years. The story was broken by the Wall Street Journal about HP's German subsidiary paying bribes to sell hardware to the Russian prosecutor's office. The original matter was brought to the attention of the German authorities, who raided the HP's regional office, or German national office rather, in Munich, and arrested certain HP employees out of that office. This led to a much broader internal investigation by HP when they found evidence of bribery not only in the German office, but also in Poland and in Mexico. Interestingly, HP received, I believe, a $152 million fine in this case, but really the most interesting thing was that the fine was far below the minimum, even in the minimum range suggested by the sentencing guidelines. This indicated that even though there was a widespread culture of corruption within HP, or at least failure of internal controls, that and significant bribes paid, HP did probably just a fabulous job in remedying these issues and coming out on the other side. The clear message from, I think, the HP matter was that HP, that during the pendency of any investigation, you need to remediate. And although it's not clear at this point what remediation HP engaged in specifically, because it was not part of the settlement documents, which included a criminal plea, a deferred prosecution agreement, and a non-prosecution agreement, for the three different country subsidiaries. HP, however, apparently did a fabulous job in remediating the situation and cooperating with the Department of Justice on a go-forward basis. So kudos to HP for coming out on the end. I think the significance is, particularly if you're in the high-tech software computer industry, that this the bribery schemes that HP engaged in are things that you need to take a look at and see if your company has any exposure. The failure of internal controls by HP might be mimicked by other companies, and certainly the models that HP used in the bribery schemes are something now that the Department of Justice will be quite familiar with. Much like the Panalpina case was for the energy industry, I think the HP case may portend more enforcement actions out of the tech industry, because so much of that industry relies on non-employee sales force, such as representatives, sales agents, distributors, and other third-party business representatives who may engage in nefarious conduct which would violate the FCPA. But once again, kudos to HP. A great learning experience, lessons learned if you're in the tech industry. I encourage you to read the settlement documents. I've written extensively on it. I'm happy to share anything I've written. There were several cases involving individuals which were significant in the first half of the year, although not happening in the first half of the year. I'd like to highlight two, and one I'd like to start with is the Sillens case, Frederick Sillens, and the BSRG matter in Guinea. Sillens was an employee of, or at least associated with, BSRG, and he was found to have engaged in obstruction of justice in trying to purchase back certain documents purporting to show bribes paid by BSRG to the one of the wives of the then president of Guinea. He was caught on tape trying to get contracts back, which alleged that bribes were to be paid, and he ended up pleading guilty to this, and I think he received a 2 or 3 years, 2-year jail term for this. There have been no formal allegations made against BSRG. It's believed that there's an ongoing investigation, and indeed the obstruction of justice claim arose from a grand jury investigation regarding BSRG. So we'll have to wait for developments to see if anything comes out against the company in that matter. A couple of other noted enforcement actions against individuals. Once again, Alstom, one more of the Alstom executives pled guilty to allegations of bribery in the Indonesian electrical service contract. The Serious Fraud Office in the United Kingdom is been cleared to bring criminal charges against Alstom. So that makes 3 out of 4 indicted Alstom executives who've now pled guilty, former or current executives pled guilty in that matter. Interestingly, as I think probably everyone knows, GE has bought Alstom, and so it's will be interesting to see how that all plays out going forward. For those involved in mergers and acquisitions, I think this case will be a bellwether to show that even though a target company may have engaged in bribery and corruption and is under significant investigation by multiple authorities across the globe, that you can, if you follow the prescriptions laid out in the FCPA guidance issued in 2012 by the Department of Justice and Securities and Exchange Commission, you may be able to absolve yourself of any FCPA liability going forward. Certainly GE is well known for having a best-in-class and certainly maybe a gold standard compliance program, and having those protections in place not only will give the government some comfort, but may show us the way, those of us in the field, the way going forward that you need to engage in. There was one more arrest in the Direct Access Partners case. A former CEO of Direct Access Partners pled guilty. This was the case where Direct Access Partners paid bribes to a official of the Venezuelan National Bank, Bandes, to obtain contracts to do transactions for that bank. So we have the CEO of Direct Access Partners pleading guilty. We have Firtash and Associates. This was a very interesting case, sort of the old guard from Ukraine, Charges were brought against one of the officials from this company to actually Mr. Firtash for paying bribes into India to obtain titanium mining rights. So it's going to be interesting to see how that case goes, whether that gentleman can be extradited. He was arrested in Vienna, but he was not extradited to the United States, and he was allowed to, I believe, pay bond. But whether we ever see him in the United States, who knows? An interesting case was brought against Petro Tiger, a Houston-based energy company, for paying bribes into, I believe, Chile. Two of the company's executives were arrested, and one of them, the CEO of the company, is fighting those charges. Two of the others have pled guilty. So we may actually get to see another FCPA case go to trial, which will be quite interesting. On the side of the individuals, I'd like to end with, I mentioned two that were significant. The second is more of a non-event than a significant event, and that may make it significant in and of itself, and that's the Securities and Exchange Commission prosecution of Noble Energy executives, or Noble Corp executives. Noble Corp had pled guilty and accepted a DPA for FCPA violations coming out of the Panalpina investigation, and certain of two of its executives three were charged. One pled out early, but two fought the charges. These, I should say, they're not criminal charges. They were civil actions brought by the Securities and Exchange Commission, basically books and records violations. Excuse me. The Securities and Exchange Commission had their cases whittled down, and basically they settled with the individuals. The individuals agreed to cease and desist orders. The cease and desist orders specified that they would not violate the FCPA going forward, which of course that's the obligation of every American. So when you have a settlement where two executives agree to follow the law that they are under an obligation to follow anyway, that's a pretty clear indication that the prosecution was not successful, or at least the civil enforcement action was not successful. So that in and of itself, I think, is certainly significant. Turning to an opinion release, we've had one opinion release to date this year. That's opinion release 1401. In that opinion release, a gentleman who was a private citizen entered a contract with a U.S. company. He later became a governmental official. He needed to be bought out of his contract. At the time the contract was executed, it had a formula for a buyout clause, and the buyout clause apparently was set up such that it was during the financial crisis of 07, 08, 09, that he would have received either nothing or negative value for his buyout, which he was not willing to do. So the question posed to the Department of Justice under the opinion release procedure was, could these clause be changed so that a more fair or an appropriate value be assigned to the buyout, even though he was now a governmental official? There were multiple protections put in place. Of course, there was full transparency with the company, the government involved, and there was a reputable third party who the parties agreed could assign a value to the contract, and the buyout clause could be based upon that. The significance of this opinion release, I think, was twofold. The first one was the length of time. The length of time was certainly less than 6 months, which shows that the opinion release procedure does work. If you have questions, you can pose them to the Department of Justice and receive an answer in a relatively short time. And this answer, I think, can certainly, while the government would never say it's a safe harbor because it's only based upon the facts and representations made to it, I think it can give you a very large amount of comfort if you have a difficult question that you want it to move forward. I continually talk about the Halliburton opinion release 0802, and that was a situation where Halliburton was in the middle of a attempted acquisition, and they didn't feel like they could move forward, but put a question to the Department of Justice and proposed solution to the DOJ, and an opinion release was granted by the DOJ, specifying if Halliburton took certain actions that were detailed in the opinion release, the Department of Justice would see no FCPA violations. I think the point of all of these opinion releases, and 1401 re-emphasizes again that the opinion release procedure is out there, and it's an available tool for the answer of business questions in the context of the FCPA. While I probably would have not given the same answer that the Department of Justice gave in the opinion release, meaning I'm continuing to be surprised by some of the answers the DOJ gives. Nevertheless, it shows that it's an important tool, and it's an important tool that I think that you can use going forward. The next general area that I think is important about the FCPA is something that Scott Killingsworth and I have both written about, and Scott has given it the name private to private, or P2P. And in it, it really talks about the business answer or the business response to anti-corruption compliance, anti-bribery compliance across the globe. And that is that companies are driving a business solution to anti-corruption or bribery and corruption. And this business solution is essentially that mega company A does business with slightly smaller company B. It requires slightly smaller company B to have a FCPA compliance program in place. It will audit and or test that program, and then it will require slightly smaller company B to have similar compliance terms and conditions with those it does business with, so that it drives compliance down the chain. I've seen this most often occur in the energy industry in Houston, because Houston, for better or worse, is the FCPA enforcement epicenter of the world. That's led to a wide variety of maturity and compliance programs. So you can bet that the Exxons, the Shells, the Chevrons of the world are going to have a gold standard compliance program. Anyone that does business with them has to have a compliance program. But it's not just the Halliburtons, the Schlumbergers, and the Weatherfords, the sort of mega big company, that also have compliance programs. It's if you want to do business with a Halliburton, a Schlumberger, or a Weatherford, you have to have a compliance program. And I've seen $15 million software companies have to have a compliance program in place if they want to do business with any of the mega big companies. So the Scott Killingsworth has put a theoretical framework around this, and once again he calls it private to private. I call it a business solution to a legal problem. Whatever you call it, I think we see businesses now requiring compliance solutions in their contracts. We see banks requiring compliance programs as part of lending covenants. We see private equity firms requiring compliance programs. If you want to list your company on a U.S. public exchange, you have to have a compliance program, so that if you want to access the cash in your company, you're going to have a compliance program. I applaud this as a business solution to a legal problem, and it's going to be interesting to see where it would go forward. I'd like to end up today talking about the Eskenazi decision, because this may be the most significant FCPA-related event of at least the first half of 2014. The Eskenazi decision, which I've written about extensively, as have a number of other commentators, was an appeal to the 11th Circuit Court of Appeals. It was the first time we've had the a Court of Appeals pass on the question of whether a state-owned enterprise is an instrumentality under the FCPA. And I think in a resounding decision based on largely on common sense, the 11th Circuit said yes, that the Haitian National Telecom Company was a state-owned enterprise run by the government of Haiti. I think the key point of the Eskenazi decision is control. They broke the test down into two components, a control test and a function test. And let me actually read from those. Decision. And it said that under the control test, the government would ask questions, or you should ask questions like, does the foreign government have a formal designation of the entity? Whether the government has an interest in the entity? the government's abilities to hire and fire the principals of the company, the extent to which the entity's profits go back to the government, the extent to which the government would fund the entity if the company failed to break even. Under the function test, they listed 4 prongs. Does the entity have monopoly power in its function in the country? Does the foreign government subsidize the entity? Does the entity provide services at large in the foreign company? And does the foreign government generally, is it perceived to be providing a government function? Is the entity perceived to be providing a government function? But really the key is, does the government control the entity? Whether that be putting people on the board of directors, whether that be taking the money, whether that be guiding it in some way, whether it's perceived to be run by the government. All of these questions, the 11th Circuit said, although they've given a list of questions, that you don't really, or rather there may be other questions, and certainly other courts have posed other questions. I think the question you need to ask is, does the government control it? And are there indicia of control of the entity being owned by the state? If they're owned by the state, they're going to be an instrumentality under the FCPA. But it was pretty clear from the facts in the case that Haiti Telecom was run by the government, and so that's why, to me at least, common sense prevailed in this decision. Nevertheless, it was a very significant case. First time we've had 11th Circuit rule on the FCPA. The first time we've had a Court of Appeals rule on the FCPA in some time. And unfortunately, it may be quite a long time before we have another Court of Appeals ruling on the FCPA. Certainly this decision could be appealed to the U.S. Supreme Court, although since there's really no disparity between the circuits, I doubt the court would take this case or rule on it. So that is really what I think are some of the significant highlights of the first half of 2014. I've written about these extensively, so if you want to take a look at some of my articles, you can go to the FCPA Compliance and Ethics blog, or if you have any questions about any of the foregoing, you can contact me at tfox@tfoxlaw.com. I hope you enjoyed this episode and look forward to visiting with you again.